So I wanted to say a little bit about Vince Davis, who has been my attorney. My case turned out to be a little more severe than what we had all realized it was. And with that being said, he is a attorney who goes above and beyond and is the cream of the crop, in my opinion, with what he does and how he does it.
Welcome, and good morning. Welcome to my CPS office hours. I'm Vince Davis, and today I'm going to show you something very few people think is even possible. How to flip a CPS case that's going against you and win it back. If the judge ruled against you at any hearing, if your rights were limited, if your child is in foster care, I'm here to tell you the case is not over. For the next 30 minutes, I'm going to show you how to flip the script. Use legal tools the system won't tell you about and make them reconsider everything in your case. If you're in a case right now and the odds are stacked against you, I want you to call my office today. Let's fight back together. Okay, here's step one. Accept that you're losing the case, but the case is not lost. If the court has removed your child from your home or ruled against you at the detention hearing, the jurisdiction hearing, or the disposition hearing, or one of the 6-month review hearings, you are behind the 8 ball. You must shift from survival to a comeback strategy. Now remember this. Comebacks require different tactics than defenses and different than offenses. Step 2, find the weak points in CPS's case. Review all filed social worker reports. Look for all the hearsay statements. Look at all the incomplete evidence against you. Look at all the missing medical, school, or police records. Highlight inaccuracies and file a rebuttal declaration with all of your exhibits. Step 3. Determine with your attorney whether you should file motions that they don't expect. Most parents in most CPS cases never file any motions. Here are some of the motions you can talk to your attorney about filing. File a motion to modify placement. File a motion to increase your visitation. File a motion to return the child. File a motion for change of court-appointed counsel. Surprise changes everything. Step 4. Use the 388 motion like a weapon. It's the most powerful, underused tool in the juvenile court. You can use it to request reunification, more visitation, new placement, and expanded services. Now remember that it's more than just the 4-page form. A lot of people file the 388 and they just file the 4-page form. The judge denies it and they scratch their head. What happened? The other day, I reviewed a 388 that we filed, and, I had help preparing it, one of my paralegals, but it was truly a work of art. Yes, it had the 4-page form that you get, the JV 180, or it's the JV, I forget what number it is, but it's the 388 form. And it had connected to it a declaration from witnesses under penalty of perjury. And each declaration had exhibits attached to it. Key exhibits like my client's certificate of completion, letters of progress, declarations of important witnesses. And those witnesses' declarations had exhibits, school records, records from the pastor, school attendance records, medical records, letter from the therapist. And then on top of that, the coup de grace was the legal points and authorities. Now, if you don't know what that is, it's legal arguments citing to cases and statutes to support all of the facts that you've presented to the judge to compel the judge to rule in your favor. A lot of times 388s aren't filed with legal points and authorities. I don't know if the California rules of court require that, but I think it's the best practice and it's overlooked a lot of times. Step 5. Flip the narrative with new evidence. You should consider submitting updated parenting class certificates, new therapy evaluations, letters from neutral professionals, employment records, housing records, sobriety proof. Show the court you are not the person CPS painted you to be. I'm in the process of one case where the case plan actually called for my client to have a psychological evaluation or psychiatric evaluation, excuse me. And the psychiatric evaluator determined that my client should go and be evaluated by a psychiatrist to see if she needed medication. The social worker downplayed that my client go have that done. My client determined by herself that she shouldn't have it done. Subsequently, she hired me and she told me, Mr. Davis, I've done everything. In the process of preparing her 388, I realized that she hadn't done everything. And it was going to be used against her at the 6-month hearing and in my 388 as a defense to deny it, saying she hadn't done everything. You see, the social worker, in my opinion, had left herself a hidden out. Yes, a reason not to give her back the child, even though she downplayed it, even though she made it seem like my client had done everything. So what did I do? The very first thing I had my client do is go out, get evaluated by a psychiatrist to see if she needed medication. Lo and behold, the psychiatrist says, "Oh, you don't need medication." Well, doctor, would you put that in a letter, please? We get the letter, we send it to the social worker, we put it in our 388, and we file our 388. What happens a few days later? Social worker sends out an email to everyone. "Oh, I think the mother should have unmonitored visits now," right? We're still going forward with our 388, which is asking for return or overnight visits. But now the social worker is softening the position because now the social worker realizes mother truly has done everything. All right. Don't forget, if you have questions, put them in the comments section. And at the end of this, I'm going to try to take some of your questions. Step 6. You can talk to your attorney about this, consider filing a motion for a new judge. Or maybe you can get a free consult, consider getting a new attorney. I get a lot of calls that people tell me, well, my court-appointed attorney isn't fighting for me. Now, in California and in other states, you can ask for a new court-appointed attorney. But it's not easy to get that motion granted. A lot of people think you can just go into court and say, hey, judge, I don't like this guy or I don't like this gal. I need a new court appointed attorney. That's not enough to get that new court appointed attorney assigned. You actually have to have facts to show that there's a conflict between you and that attorney. And the conflict can't be I don't like the guy or I don't like the gal. In California, there's actually a written motion that's best practices that you should file. On my YouTube channel, I have a video on this. You can go through that video, search Marsden, Marsden motion, or you can just Google it and find a form. It'll show you the things that you have to show the judge in order to get a new court-appointed attorney. Now, if you believe your judge is biased, you should talk to your attorney. In California, you can file a motion, a 170.6 motion, a 170 motion, a motion for recusal. A 170.6 is something as an affidavit you can file at the beginning of the case to get a new judge. But after the case is begun, in order to get a recusal of a judge, you have to file an actual motion. And it's in the one section area. I think it's a 170.8, but I forget. But the motion, this is the key thing I wanted to tell you. That motion cannot be heard by the judge in California. As a matter of fact, that can't be heard by the judge in the building. As a matter of fact, it can't be heard by any judge in the county. It has to be sent to a judge outside of your county. Now, a lot of times they'll ask you or your attorney, so make sure your attorney doesn't agree, can it be heard by another judge in the building, or can it be heard by another judge in the county? It's been my practice to always say no. The statute actually says that it should be heard by another judge in another county. But that's a strategy call that you and your attorney should make after you guys consult and confer. But make sure that your attorney knows that you know that the motion shouldn't be determined by, or should be determined by, a judge in another county. All right, step 7. You got to build a witness list to change the game. List people who will testify in your behalf, depending on what stage of the case you're at. For example, teachers, daycare workers, therapists, extended family, service providers, your drug counselor, your domestic violence counselor, your parenting instructor, your individual counselor. Okay? List those people and talk to your attorney about getting declarations from them, getting statements from them, having them come to court. You know, I talk to a lot of witnesses that say, hey, I don't want to come to court. Nobody wants to come to court to testify. Well, sometimes that's not their prerogative. They can be forced to come to court to testify with a subpoena. All right, that's the price of living in America, that if you're subpoenaed, you should come to court and you should testify and tell the truth. What I like to do is file a witness list with declarations, because sometimes, you show the court or you show the social worker what a certain witness is going to say, and, they may give in. Step 8. One of the things that you should always consider is the change of placement. Change of placement can cause a change in the outcome of the case. If the child is in a terrible foster placement, request a move. Purpose of a change in placement is get the child with family or friends. Get the child with a respected guardian. Consider the kinship placement. The child's well-being, the arguments often win hearts. I often say that getting a child out of foster care and getting the child placed with a friendly relative or family friend is just like you being in jail and getting bailed out. That's how significant the change in leverage is in the case. Step 9, go on the offense against the social worker. You might want to track the social worker's failures. For example, social worker didn't give you referrals, didn't follow up for you, missed visitation facilities, missed giving you the visitation. All of those matter because at any particular hearing, your attorney and you can bring up the fact that you haven't been given adequate family reunification services. And the judge has to make the findings that the social worker gave you adequate reunification services or reasonable reunification services, because that is the voucher the social worker in the county uses to go get federal funds for your case. You can file grievances, you can issue subpoenas, and you can file complaints with your county supervisor here in California. Make CPS defend themselves. That's why I say go on the offensive. All right, step 10. Consider using public pressure, strategically though, because these cases are confidential. And if you make them non-confidential, you can suffer criminal prosecution. You can share your story on social media, but you can't use the name of the child. Ask community leaders to send letters in support of you to the social worker, maybe even to the judge if your attorney recommends it. Don't rant, educate people. Remember, your tone equals credibility. The story equals power. All right, step 11. Prepare for trial like it's life or death. Get your exhibits together, pre-mark your exhibits, rehearse your testimony with your attorney. Remember, always tell the truth. Build visuals, if allowed, charts, timelines, photographs. Trials are won usually in the preparation of trials, not during trial and not during the reaction. Step 12, file the appeal if you have to. If the judge rules against you at .26 hearing on the termination of your parental rights, at your 388 hearing, at your 6-month hearing, at your disposition hearing, consider with your lawyer filing the notice of appeal. You may still win. Have I ever seen a person lose their parental rights and get them back on appeal? Yes, I have. File your appeal. Notice of your appeal, must be filed in a certain amount of days, depending on your state. In California, it's 60 days. Have I ever seen people miss filing the notice of appeal? Yes, I have. When your family reunification rights are terminated, you have to file a notice of intention to file a writ, not a notice of appeal. And that has to be filed within 7 days. Have I ever seen people miss that? Yes. Have I ever seen people, including attorneys, get mixed up and file a notice of appeal when they should have filed a notice of writ? Yes, I have. Talk to your attorney. Make sure you're filing the right type of document. You may want to call an appellate attorney immediately. Call me. We handle those types of cases. Most parents give up because they think it's over. But I have helped hundreds flip their case, and I can help you too. Call me today, book a strategy call. Let's flip your case and bring your children home. I'm attorney Vince Davis. Let's turn the tide today. All right. We have a few moments together. Let's take some questions. Betty Joe on Facebook says, why would GAL ask for discovery if they are doing a TPR? Betty Joe, there are many reasons why a GAL would ask for discovery. I couldn't guess, but discovery is one of the easiest ways to find evidence to support your cause or to defend your cause. And I don't know why, but it's best practices always to ask for discovery, no matter what point in the case you're at. Okay, Brittany McCarrick from Facebook says, have you ever come across a client that after months of asking, they finally give you a DSL, which is a delivered service log that is only for the last 4 months of what has been going on? Now it's been longer than 4 months, but at the time it was 4 months that they had given it. And when going through it, was only good about 2 of the 4 children. And when looking over in my computer, they didn't correctly go about removing their actual comments and commentary in the delivered service log, so I'm able to see what they are actually saying rather than... I don't think Brittany finished her question or her thought, but it's important in a lot of cases to get the DSL, the delivered service log. You can only get those through your attorney or by asking for discovery. So a lot of times DSLs will tell you very important things about your case, and it will also give you important evidence that you may be used in your defense. And it may give you an important insight as to how the social workers are thinking about your case, just their general attitude about your case, as well as giving you, that exculpatory evidence that you can use during the case and during trial. All right, I don't see any more questions today from our audience, which is unusual. Okay, I see Risen Rare Gem from YouTube says, hi, Mr. Davis. This is Marge. Hi, Marge. How are you? More people keep coming on, but no questions. All right. I have a hearing this morning, so I'm going to leave early. And I'll see everyone tomorrow at 6:30 a.m. Pacific Standard Time on office hours. Stay safe.
Vince has been an angel, I believe, in my opinion, for me and my family. I would not turn to anybody else. I believe that he is an over-the-top individual that genuinely is there to fight the good fight. I would go to nobody else other than Vince, and I give him my thanks for getting me and my kids where we are today and putting us at ease. Thank you.